were about 2 minutes into our argument when we had to stop. I think the best thing would be to start all over again. My Lord, we have filed heads of argument regarding the application that the state wants to bring for leave to cross-examine Mr. Sifiso Gwabini Zungu on his extracurricular statement. And in the introduction, my Lord, we mentioned that the state seeks to cross-examine a defense witness, Mr. Sifiso Gwabini Zungu. He is popularly known by his clan name Gwabini, on his extracurricular statement, which he had made in terms of Section 204 of the Criminal Procedure Act, number 51 of 1977. We mentioned that he has been called as a defense witness on behalf of accused number 1. In paragraph 1.3, we mentioned that the defense counsel for accused number 1 is objecting to the cross-examination of Mr. Sifiso Zungu on his extracurricular statement on the basis that the statement has been proven. My Lord, we will advance the argument that his own defense counsel has taken him through that process of proving the statement, and we will revert to this point in greater detail during the course of our argument. We submit, my Lord, that at this point the only question is what to make of his explanation. We submit that the point is that his explanation must be tested as to reliability through cross-examination. We submit that it's a credibility issue, my Lord, as to whether his statement is trustworthy, and therefore that the statement itself needs to be examined through cross-examination. We mentioned, my Lord, that Mr. Sifiso Gwabini Zungu was initially on a list of state witnesses for the state, but he was not called as a state witness. The reason why he was not called as a state witness was mentioned by Brigadier Gininda during his evidence, and we refer to the record of the 6th of June 2025, page 75, Brigadier Gininda, and we quote his evidence. I'm going to say it with utmost respect, but I will say it as it is. During the consultation with the state, that is now Mr. Sifiso Gwabini Zungu, he indicated that he was fearful of his life, and we close the quotation. My Lord, we submit that when a witness has been made available to the defense, the position is that if the defense make use of such a witness, they will make use of the statement that he or she has made. That will be the whole basis of calling that witness. We submit that you cannot call a witness who does not confirm his or her statement. The statement serves as a basis of his or her evidence. If the witness does not confirm the statement or deviates from it, the procedure as outlined in Section 190 of the Criminal Procedure Act must be followed. And for ease of reference, we refer to that section, which reads as follows. The heading is impeachment or support of credibility of a witness. Subsection 191 reads as follows. Any party may, in criminal proceedings, impeach or support the credibility of any witness called against or on behalf of such a party in any manner in which and by any evidence by which the credibility of such a witness might, on the 30th of May 1961, have been impeached or supported by such party. And subsection 2, any such party who has called a witness who has given evidence in any such proceedings, whether that witness is or is not, in the opinion of the court, adverse to the party calling him, may, after such party or the court has asked the witness whether he did or did not previously make a statement with which his evidence in the said proceedings is inconsistent, and after sufficient particulars of the alleged previous statement to designate the occasion when it was made have been given to the witness, proof that he previously made a statement with which such evidence is inconsistent. My Lord, we submit that if his testimony was inconsistent with the statement, then the defense should have followed the procedure as set out in subsection 190, subsection 1 and 2, which was not followed. In paragraph 1.5, Brigadier Gininda testified that he learned of the presence of Constable Sizwe Skhumbuzo Zungu at Basotho Hostel on the 26th of October 2014, from where the death of the deceased was planned, from inter alia the statement of Mr. Gwabini Sifiso Zungu. And this, my Lord, we see on the record of the 8th of November 2024, page 60, Brigadier Gininda. Yes, my Lord, I think one statement that comes from the top of my mind is the one of Gwabini Sifiso Zungu. It guided me to that effect because he places the 5 accused, and I think it talks to that issue of contractual killing. There are other statements, my Lord, which may be involving not collectively, but some of the accused, individual. For example, accused 3 and 4 were almost similar assertions are made. So there are different statements in the docket, and I can be specific, my Lord, if that is needed. But one of them, like I said, it is Sifiso Zungu. Brigadier Gininda, no, Sifiso Zungu and Gwabini Zungu is one and the same person. We close quotations as far as that portion of the evidence is concerned. In paragraph 1.6, he testified further as follows in this regard, and we refer to the record of the 1st of November 2024, pages 25 to 26. Brigadier Gininda, yes, my Lord, there are statements that I obtained I am just not sure if those witnesses have testified, but during the course of the investigation, before Constable Zungu's statement was obtained, there were other statements in the docket, and he says, before the statement of Constable Zungu was obtained in 2023, June, that is when it was obtained, and we close quotations as far as that portion of the evidence is concerned. And we then asked Brigadier Gwininda to explain the circumstances under which the statement of Constable Zungu was obtained, and he testifies as follows. Says, so during the course of the investigations, my lord, that is now after or during the course of the investigation of this matter, the name of Constable Zungu came up as a person who was present at the hostel on the 26th of October 2014. So it came out during the course of the investigations when I was interacting with other witnesses that I have referred to, who deposed to affidavits. Subsequent to that, my lord, he was then approached because I received, I think it is more than one statement where his name kept on coming up as the person who was at the hostel on that day, my lord. When I confronted him, my lord, the report I got was that he was fearful of reprisal since he knows the accused, but also wanted us, according to what he told me, to do our own investigations without him having to influence us. He then, my lord, agreed that he will then depose a statement in so far as what he knows and recalls, my lord. And that is how that statement came about, my lord, at a later stage. But prior to this, my lord, as I indicated, there were statements already in the docket because that matter, or this matter, was already on the roll. We were busy with the trial. Prior to Constable Zungu, there were already statements on the docket that implicates the accused collectively or individually, but there were such statements, my lord. Then we then deal with the evidence of Constable Size Zungu. In paragraph 2.1, we mentioned that in light of the evidence of Brigadier Gwininda, that he learned of the presence of Constable Size Zungu at Basotho Hostel on the 26th of October 2014 via inter alia the statement of Mr. Sifiso Gwabini Zungu, that it is opposite to set out his evidence. And in paragraph 2.2, we mentioned that Constable Size Zungu has testified as an eyewitness of the events that occurred at Basotho Hostel on the 26th of October 2014. And, my lord, we quote extensively his evidence, which appears in the record of the 7th of September 2023, page 4 and further. My Lord, in light of the fact that his evidence has been traversed to a greater extent, we are not going to rehash his evidence. Is there in our heads. We will request then to turn to page 16, is paragraph 2.6. We make the submission, my Lord, that from the foregoing, it becomes clear that the evidence places Mr. Sifiso Gwabini Zungu at the center of events on the 26th of October 2014, and that his evidence needs to be placed before this court in its entirety. Then we deal with the evidence of Mr. Sifiso Gwabini Zungu in paragraph 3. In paragraph 3.1, we mentioned that Mr. Sifiso Gwabini Zungu has testified that he had just arrived at the hostel from home, that is his home village, when the police came to search his room on a Monday in June 2020 at 2300 hours and arrested him for possession of firearm, which he says Constable Mapumulo squeezed underneath his mattress. When he inquired from Constable Mapumulo as to why he was planting the firearm, he slapped him. Accused number 1 is his brother. Their mothers are sisters. The accused, that is now accused number 1, had called him on a 073 number to alert him that he has been arrested. That is now accused number 1 has been arrested, and that the police were looking for him. That is now we're looking for Mr. Sifiso Gwabini Zungu. He testified that he would not have kept the firearm after this warning by accused number 1, paragraph 3.2. He testified that he was placed in a red Golf 7, driven by Sergeant Mohani and taken to a municipal area near the police station. En route there, he was shown photos of 2 ladies from the Sibia family on a tablet-like cell phone. Upon arrival at the municipal area, he was made to sit down, legs stretched and handcuffed at the back, a plastic put over his head by an unknown Metro Police officer, that Constable Buthelezi pressed his boots on his handcuffs and kicked him like a drum full of water, that he rolled for about 5 meters whilst being interrogated about the death of Mr. Senzo Meyiwa, paragraph 3.2. He testified that it was between 12 o'clock midnight and 1 o'clock in the morning. After the assault at municipal area, he was taken to a graveyard where he was further assaulted. Constable Mapumulo kicked him with his knee on the chest. He was assaulted until 4 o'clock in the morning, leading to him sustaining an injury on the left arm, measuring 4 centimeters in length and 2 centimeters in breadth, and a 1.5 centimeter scar on the right wrist. He testified that he was first taken to Goldsport Police Station, made to sit, and forms were completed, and his thumbprints were also taken, paragraph 3.3. He was then transferred to Primrose Police Station. He arrived there at 4:20 a.m. When he asked a police officer what time it was, he said it was 5 o'clock in the morning. He was placed in the cells by Sergeant Mohani. He borrowed a phone from one of the police officers to phone for a jersey, as he was called, and water was poured over him. He testified that Sergeant Mohani visited him on Tuesday and told him that since he is wearing a jersey, it means someone knows that he is detained. Paragraph 3.4. The following day, on a Wednesday, Sergeant Mohani came to fetch him from the cells and took him to an office where Brigadier Gininda and, as he called her, Mamfundisi, but it refers to Sergeant Mohola, were in order to make a statement. This is, my lord, where we say that the defense themselves have laid the basis for the statement. Sergeant Sergeant Mohane left, and it was only himself, Brigadier Gininda, and Sergeant Mohola in the room. He testified that he was not aware what the statement was for. They explained that as an arrested person, he has rights. They gave him a document which he did not read. Brigadier Gininda was leading the interview. They informed him that they were going to write a statement about him. He then told them that to bring over maybe before that, he told them that he has nothing to do with soccer. They asked him about the South African goalkeeper. He said he does not watch soccer. They said it will be beneficial if something is written down as Muzi, referring to accused number 1, has written about him. He then told them that to bring over what Muzi, or accused number 1, has written. Maybe he, that is now accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Muzi, accused number 1, has said to the document, that is now the statement. He then wrote an S on that document. We submit, my lord, that as we have just submitted, that the defense has laid the basis for the statement, and the circumstances under which the statement has been obtained have been placed on record. That Sergeant Mohola showed him a picture on the phone depicting Mafika, there's reference to accused number 2, wearing a long-sleeved red shirt, jeans and Cavella shoes, and was asked if he knows him. He said he knows him. He is from back home. Sergeant Mohola said they were also looking for him. That is now accused number 2, Mafika. He said the statement was made at night. He was then taken back to the cells. With this background, my lord, we submit therefore that the basis has been laid regarding the circumstances under which the statement was obtained. In paragraph 3.5, it testified that on a Monday they came to fetch him and he was taken to Golden Sport Police Station at Vosloorus. He was taken to the holding area at the back of the court, but he did not appear in court. The driver of the red motor vehicle, with reference to Sergeant Mohane, said bail in the amount of 2,000 will be needed. He gave Sergeant Mohane the 2,000 which he had borrowed from his brother, Mr. Tungisa Mabaso, and Lungisani, with whom he stayed, went to collect the money after he had borrowed a phone to make these arrangements. Paragraph 3.6. Mr. Sifiso Gwabini Zungu testified about events during the consultation with the prosecuting team, despite objection by the state that those events were irrelevant. He testified that when he came for the first consultation, he saw Constable Zungu emerging from the consultation venue at the office of the Director of Public Prosecutions. He said when the prosecuting team mentioned that he was supposed to be going to court, he answered that, and we quote his evidence, "I had no problem in going to court, but fear for my life. Part of me was in prison, the other in death," and we close quotation regarding his evidence. Brigadier Dininda said that, referring to my statement, according to which I know everything, the prosecutor is in possession of the statement, which he says was written by me. The state read out the statement. When he stated that it refers to me as Gwabini, I told him that Gwabini was my clan name. I am Sifiso Zungu. He read out the part that says Sifiso Zungu stroke Nkani's silver polo was at my house. I told him that was not my statement. He asked me who signed underneath. I said I did not know. I told them that my signature is an S. They told me to leave. They are going to court, and I was told to go home. And we close quotations as far as that part of his evidence is concerned. Paragraph 3.7, he testified that at the second consultation in 2022, before Constable Zungu testified, he was fetched by Sergeant Mlauzi. He mentioned that during the consultation, he told the prosecuting team that the state is disturbing him. He is saving money for his marriage. They said your name is written on top. When the statement was read out, it said Mafika was arrested. And I asked, why did they include Mafika as I was arrested before Mafika? They told me to go home and reflect. He testified that he then went home. He testified that there was a third occasion during which he came to court but was barred from entering the courtroom and threatened by Sergeant Mohola, as he testified. Says he was taken to the upper office to claim witness fee as he had used private transport of one Mr. Gwabini. In paragraph 4, my lord, we set out the legal position. In paragraph 4.1, we refer to the case of State versus Makala and another. CCT 237/22, wherein the Constitutional Court had occasion to consider the decision of the Supreme Court of Appeal in a situation where a conviction of the two appellants was based upon two statements made by a witness who was the brother of the first appellant. When the witness was called to give evidence at the trial, without forewarning to the prosecution, he recanted the contents of his two statements that incriminated himself and the other accused in the murder. The witness testified that the incriminating portions of the statements were fabrications which the police forced him to record in his statement. In paragraph 4.1, we mentioned, my lord, that in the matter at hand, Mr. Sifiso Gwabini Zungu was initially a state witness, but he was not called as he expressed fear of reprisal and has now been called as a defense witness. He testified that he and accused number one are brothers. As we mentioned, the mothers or sisters. And he refers to accused number 4 as uncle. He knows accused number 2, who grew up in a nearby village called Kotlokolo. In Makala's case and another, the Constitutional Court confirmed the findings of the SCA that the witness was a brother of the first applicant, and that is probably the reason why he reneged. In this matter, my lord, we make the submission that whilst that Mr. Sifiso Gwabini Zungu has not specifically recanted his statement, but has testified that when Brigadier Gininda and Sergeant Mohola came to interview him at Primrose Police Station, they informed him that Mozi, that is now accused number 1, has already made a statement about him. They said it will be beneficial if something is written down as accused number 1, Mozi has written about him. He then told them to bring over what Mozi or accused number 1 has written. Maybe he, that is now accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Mozi has said to the document that is now the statement. He then wrote an S on that document. In paragraph 4.2, the SCA considered whether the witness, and his name was Luzuko Makala, had been coerced to make a statement by the police, and as to whether he did not do so freely and voluntarily. The appellants contended that the two statements were not made voluntarily. Rather, they were induced by false promises that he spoke under indemnity of prosecution. In paragraph 4.3, the Constitutional Court held that the witness in the Makala case had distanced himself from the statements and had absolved the applicants. He testified that he was lying to the police when he made the statements. In the current case, Mr. Sifiso Gwabini Zungu does not dispute that he made a statement. All that he says is that they, that is now Brigadier Gininda and Sergeant Mukhola, said it will be beneficial if something is written down as Muzi or accused number 1 has written about him. He then told them to bring over what Muzi or accused number 1 has written, and that maybe he, that is accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Muzi has said about him to the document that is now the statement, that he then wrote an S on that document. So, my lord, on Mr. Sifiso Gwabeni's own evidence, he was not coerced to make a statement, but did so freely and voluntarily. Whilst he was arrested on a charge of possession of firearm, he made the statement regarding the death of Mr. Senzo Meyiwa willingly, freely, and voluntarily after being warned in terms of Section 204 of the Criminal Procedure Act. He testified that his rights as a suspect in the possession of firearm case were explained, and a document was given to him which he says he did not read. My lord, there's no indication that he did not understand what was being said or that he wished to consider his position. In paragraph 4.4, the Constitutional Court had to consider whether the statement by the witness, Mr. Lizuko Makala, constitute hearsay evidence in terms of the Hearsay Act. And in this regard, we refer to paragraph 67 of the judgment. It referred to the definition of hearsay evidence in terms of Section 3 in brackets 4 of the Hearsay Act 45 of 1988, which was quoted as follows. Hearsay evidence is evidence, whether oral or in writing, the probative value of which depends upon the credibility of any person other than the person giving such evidence. And we close the quotation. The Constitutional Court held that the witness was the author of the two statements. He was called at the trial to testify. His version was that he lied to the police who took down the statement. The probative value of the statements therefore depended upon his credibility. In the current case, Mr. Sifiso Gwabeni Zungu is busy testifying. His version is that Brigadier Gininda and Sergeant Mukhola said it will be beneficial if something is written down as Muzi, accused number 1, has written about him. He then told them to bring over what Muzi, or accused number 1, has written. Maybe he, that is now accused number 1, did not know that he knows nothing. He testified that he asked them to transfer what Muzi has said about him to the document that is now the statement, and that he then wrote an S on that document. In paragraph 4.5, We make the submission, my lord, that the credibility of these assertions depends on Mr. Sifiso Gwabini Zungu, who's busy testifying, and that the statement is therefore not hearsay evidence. We make the submission, my lord, that this court can either find that Mr. Sifiso Gwabini Zungu is a credible witness or not. But in order for the court to do that, we make the submission that cross-examination on the statement must be allowed. The Constitutional Court at paragraph 67 quoted with approval the findings of the SCA when it referred to the matter of R versus U. And we quote that reference. R versus U in brackets FJ makes it plain that the availability of the witness who made the prior statements to be cross-examined goes a very long way to ensure that prior statements may be admitted into evidence for the truth of their contents to permit the trier of fact to assess the evidence value of these statements. The court then quoted the following work from J.W. Strong, McCormick on Evidence, fourth edition, 1992, with approval. And we quote, "The witness who has told one story aforetime and another today has opened the gates to all the vistas of truth which the common law practice of cross-examination and re-examination was invented to explore. The reason for the change of face, whether forgetfulness, carelessness, pity, terror, or greed, may be explored by the two questioners in the presence of the trier of fact, under oath, casting light on which is a true story and which is false. It is hard to escape the view that evidence of a prior inconsistent statement when the declarant on the stand to explain it if he can has in high degree the safeguards of examined testimony." And we close the quotation. In paragraph 4.6, the SCA...
Sorry.
I'm sorry.
Just put the full citation of that case of R versus U. Yeah, because I see I've abbreviated it so that your learned colleagues can have recourse to it.
The quotation appears in the judgment of the SCA in the judgment of the acting judge of appeal, Interholter. We'll give it just now, Lord.
Is it Makhalo?
Makhala.
Makhala?
Yes, Makhala.
Is that Makhala? Eh?
Yes, in the case of
They're
Makhala.
aware of that judgment.
Yes.
Are you?
I know them Awanda Makala.
Is that the same matter?
Yes.
Yes.
Fine, as long as we all know.
Yes.
All right.
Right. Paragraph 4.6, the Supreme Court of Appeal further held that the probative value of the extracurricular statement does not depend upon the credibility of the declarant at the time they gave evidence at the trial, but at the time when the extracurricular statement is made. And we submit, my lord, that this finding by the SCA has not been overturned by the Constitutional Court. We therefore make the submission that in the matter at hand, the credibility of the statement of Mr. Sifiso Gwabini Zungu must be determined at the time when it was made and not at the consultation. Then we proceed, my lord, to refer to the minority judgment of the Constitutional Court at paragraph 82, that it was common cause that Mr. Luzuko Makala made these statements but denied the truth thereof. As a result, in terms of the definition of hearsay in section 3 in brackets 4 of the Hearsay Act, such statement does not constitute hearsay. As we mentioned, my lord, that Mr. Sifiso Gwabini Zungu does not deny telling the police that he told them, that is now Brigadier Gininda and Sergeant Mohola, to bring over what accused number 1, Mozi, had written, that maybe accused number 1 did not know that he knows nothing. He testified that he asked them to transfer what Mozi or accused number 1 has said to the document, that is now his statement. He then wrote an S on that document. We therefore, my lord, make the submission that he should be cross-examined to see if the statement indeed contain these assertions. The statement of accused number 1 to the officer, Lieutenant Colonel Mboto, serves before this court, and his statement to Colonel Khadebe, who conducted the pointings out, is also before the court. These documents need to be compared with the statement of Gwabini to see if his assertions are correct, that what accused number 1 said about him was transferred to his statement. In paragraph 4.8, we refer to again to the minority judgment in the Constitutional Court, where it held that section 2.4 is an important tool in the arsenal of the prosecution to secure convictions. It enables the prosecution to offer a witness who is implicated in a crime a discharge from prosecution in return for frank and honest testimony that attests to the culpability of one or more of the accused persons. The whole purpose of section 2.4 is thus to solicit testimony against accused persons involved in a crime of which the witness had knowledge and in which they were often involved. For section 2.4 to have any application, it must be possible for such a witness to testify against accused persons and to be cross-examined on the testimony. We make the submission that Mr. Sifiso Gwabini Zungu was initially a state witness and that his statement was taken in terms of section 2.4, that he was not called as a state witness as he expressed fear for reprisal as testified to by Brigadier Gininda, that he has now been called by the defense, that his statement in terms of section 2.4 therefore need to be scrutinized, and he must be subjected to cross-examination thereon. The minority judgment further held at paragraph 86 that, and we quote, "The next step is simply to evaluate the weight to be afforded to the statement in light of the honors to prove the guilt of the accused beyond reasonable doubt." As we pointed out, my lord, at the beginning, that this is more about the issue of credibility. Paragraph 4.9, at paragraph 93, the minority judgment considered whether section 219 and 217 applies to the statement by witness. This is in light of the decision in Shongo that admissions and confessions are only applicable, only apply to the maker thereof, or only admissible to the maker thereof. Then he held that the same is not, the minority then held that, and we quote, "The same is not true of a witness who made an extracurricular statement and is brought to court to testify." As Unterhalter AJA explained in his minority judgment, that evidence is not hearsay and that the accused has full enjoyment of the right to cross-examine the witness. Section 392 of the Constitution does not point towards a different interpretation, given that the accused retains the full right to challenge the evidence. This interpretation of the provision does not negatively impact the accused's constitutional right in this regard. It also seeks to attain an appropriate balance between the protection of the accused, their right to cross-examine, and ensuring that relevant evidence is admissible in the interest of discovering the truth. And we put an emphasis on this part, my lord, that relevant evidence is admissible in the interest of discovering the truth. The minority judgment then went further on and held that such a reading is also required by the importance of attaining a harmonious interpretation of these provisions with section 204 of the same act. The latter provision, as we saw, assumes the existence of prior extracurricular statement by the witness. Section 2.4 precisely envisages circumstances where the witness will make incriminating statements against themselves and may be discharged from prosecution due to their testimony in relation to others. A central tool is testing the veracity of that testimony is to interrogate its conformity or otherwise with the prior extracurricular statement. And that is the submission, my lord, that we're making, that this extracurricular statement that Mr. Sifiso Gwabini Zungu has made must be tested against the evidence that he gave in court. That tool will be removed in section 219 and 219A were understood to render such statements inadmissible if they applied to any witness regardless of whether they are co-accused or not. The minority judgment then held that for these reasons, this judgment finds that the prohibitions in section 219 and 219A and section 217 included, do not apply to the admissibility of extracurricular statements by a witness who is not an accused and so is distinguishable from the circumstances in the TACO. So in this case, my lord, Mr. Sifiso Gwabini Zungu is a witness and not an accused. And the reference is then made in paragraphs 109 to 110 to Wigmore on evidence, and we quote that reference as follows: the worry about the lack of contemporaneous cross-examination is also overstated. The maker of the statement is, in circumstances such as the present case, available to be cross-examined. In Wigmore on evidence, the following is said: but the theory of the hearsay rule is that an extrajudicial statement is rejected because it was made out of court by an absent person not subject to cross-examination. In the South African context, it is important to consider the right to a fair trial in section 35(3), which includes the right to challenge and adduce evidence in section 353, Roman figure 1. In my view, this right is not infringed in the circumstances discussed, given the opportunity to cross-examine the witness in question. As was stated in Matonzi, the reference to the case of Matonzi is also given in the judgment.
Okay.
We'll give the quotation if it's necessary. That there is no violation of an accused's right to a fair trial if the accused or defense has been afforded an opportunity to cross-examine the declarant and test the reliability of the statement. Then in paragraph 5, we deal with the concept of the interest of justice. In paragraph 5.1, we mention that according to the evidence of Constable Zungu, Mr. Sifiso Gwabini Zungu is at the center of events that took place at Basotho Hostel on the 26th of October 2014. We make the submission that Mr. Sifiso Gwabini Zungu has made a statement which he really does not dispute, merely saying that he asked Brigadier Gininda to transfer what accused number 1 had said to his statement. We submit that it is important to determine which parts were so transferred, to compare them with his evidence before court, and that the only way of testing his version is to go through the statement line by line to determine which parts were so transferred. We respectfully submit that as a constitutional court held in the minority judgment that, and we quote, that relevant evidence is admissible in the interest of discovering the truth. A central tool in testing the veracity of that testimony is to interrogate its conformity or otherwise with the prior extracurricular statement. We submit that to arrive at the truth in this matter, it's important that the statement of Mr. Gwabini Zungu be interrogated for conformity with the evidence that he has given in court. In 5.2, we refer to the locus classicus of R versus Hepworth, 1928, AD 265, 277, that has often been quoted in this court, where the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We submit that justice will be better served by allowing the cross-examination of Mr. Sifiso Gwabini Zungu on his prior statement. We then refer to the case of State versus Sheikh, which we have quoted previously. The quotation is in our heads, wherein the court held that the appellant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3)(a) up to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach, and we emphasize the next quotation. It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. We also refer to the case of multi-choice and others versus the National Prosecuting Authority, and another, the quotation is in our heads, where in the SCA held as follows: our Constitutional Court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the fundamental values of dignity, freedom, and equality, which are central in a fair trial. The court then quoted with approval the passage in Zukuz and others, wherein the right to fair trial was described as follows: a comprehensive right and embrace a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. We refer to the case of S versus Lamini and others, G.S. Hubert and Skitekat. The quotation is in our head, wherein Judge Krichlas then was described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore submit, my Lord, that the state be allowed to cross-examine Mr. Sifiso Gwabini Zungu on his statement. In the alternative, my Lord, and we make this submission reluctantly, but that is what the law says, according to the minority judgment, and this is the fallback position of the state. We submit that a trial within a trial be held to determine the admissibility of the statement of Sifiso Gwabini Zungu as held by the minority judgment. They held at paragraph 119 that, and we quote, "The focus of the trial within a trial is not on an accused's guilt, but on the admissibility of the admission or confession in question. The same principle would apply in the context of the admissibility of a prior inconsistent extracurricular statement." According to the minority judgment, this will also a trial within a trial to determine the admissibility of a witness statement will also cover the, in this instance, the statement of Mr. Sifiso Gwabini Zungu. Both the minority judgment went on to hold that both the prosecution and defense can then fully probe the witness about the circumstances in which the statement was given, whether it was given voluntarily, the contents of the statement, and the reasons for the change of heart. This procedure will ensure the substantive realization of the right to challenge and adduce evidence. And we also refer to the to paragraph 132 of the minority judgment, which we have already referred to as why the statement is not hearsay. And in conclusion, we refer to paragraph 140, where in the minority judgment held that it is important here to distinguish between the admissibility of the statements at the trial within a trial and the ultimate probative value of the statement in determining the guilt of the accused within the actual trial. At a trial within a trial, the focus is only on whether the statement is trustworthy. To establish that, it must cross a threshold of being sufficiently reliable to counteract the dangers attached to such statements, the lack of an oath, the ability of the judicial officer to assess demeanor, and contemporaneous cross-examination. If this threshold is crossed, the admission of this statement does not determine the guilt of any of the accused. Such a conclusion can only be reached after an assessment of the ultimate reliability of the statement in light of the totality of evidence and whether all the evidence taken together proves the guilt beyond reasonable doubt. The minority judgment refers to the different scenarios. Firstly, we just want to give that citation of R versus UFJ. It's R versus UFJ 1995, 3 SCR 764. I suppose it's a Canadian Supreme Court of Canada. Supreme Court of Canada.
Yeah, fine.
R versus UFJ 1995, 3 SCR 764. The minority judgment refers to different scenarios where a trial regarding a witness statement can be held. We don't deem it necessary, my lord, to canvass those scenarios. they appear in the minority judgment from paragraph 1, 2, 3 on page 46. The state, therefore, my lord submits that in the main, the nub of our argument is that the issues at hand, it's about the credibility of the explanation that Mr. Sifiso Gwabini Zungu has given as per his evidence, that this explanation must therefore be canvassed in cross-examination with reference to his statement, and that in the alternative, we submit as the minority judgment found that the procedure to determine the prior inconsistent statement is to hold a trial within a trial. As we indicated, my lord, that it's a submission that we do not make lightly, but that is how the minority judgment set out the law, and that will be our fallback position. My lord, this is as far as we can take this argument, unless if there are any specific issues that the court would like to
No, not as yet.
to hear.
Sorry, not as yet. We'll come to that. The interpretation, Mr. Jonas?
Then at the end, my lord, we'll just think they can all argue and then we'll summarize everything. at
After the
end.
argument.
At the end. That's correct, my lord.
Okay. What's the time now?
It's 11:44.
Let's go back for 15 minutes.